Believe it or not, cops can legally tell you your best friend ratted you out, even if they've never spoken to them. We're going to talk about 5 interrogation tricks that the courts are okay with. Let's jump right in. Legal lie number 1, what I call the snitch bluff. Your buddy already confessed and pinned it all on you. This is a true story. Fraser v. Cup, detectives falsely claimed the suspect's cousin had already confessed and implicated the suspect. The Supreme Court of the United States said that confession was A-OK. And the court said, hey, you know what? It's about the facts of the case. There's no threats or promise, and that misrepresentations are relevant to voluntariness, but hey, it's not enough to exclude the confession. Now, why this lie works? Because it plays on psychological tricks and peer pressure. The suspect starts to think, well, somebody already confessed and told them I did it. Well, no point in denying it anymore. Now, there are limits to this. Now, they can't do this and add a promise, such as confess and you'll just get probation. That's kind of where the line is drawn, but they're allowed to do this. Hey, buddy already said everything and told us all involved. That's totally fine. Now, how do you fight this? Well, when they start saying this, number 1, say, I plead the 5th. I want an attorney. In fact, you shouldn't even be in an interrogation room with the cop. What if they come up to your house or on the street and they say, hey, we know it was you. I plead the 5th. I want an attorney. Yeah, problem solved. Legal lie number 2, the Phantom Eyewitness. 3 people saw you leaving the scene. You better confess or it's going to go bad for you. Listen, Holland v. McGinnis, 7th Circuit, United States, officer invented an eyewitness report. And the 7th Circuit literally said, hey, this invention of eyewitness, that's the least likely kind of trickery to make a confession involuntary. And the court does this whole back and forth. Well, inflating evidence only forces a suspect to reckon with their own guilt or innocence. It's not really an outside threat. Now, you have to watch it because there's a line where the police can cross. So if they do like a marathon type questioning, if the suspect is physically exhausted, well, all of a sudden that phantom eyewitness can cross the line and it can cause a confession to be involuntary. But I'm going to tell you right now, an easy way to avoid this. If the police are telling you these things, if the police are talking to you, I plead the 5th. I want an attorney. Problem solved. Legal lie number 3, what I call the forensics ploy. We pulled your fingerprints or DNA off the weapon. We know it's you. Now, we'll see this in the interrogation room typically. And this is Oregon v. Mathias in 1977 case. Officer lied that prints were found on a gun. Court said, hey, person's not in custody. Simple verbal bluff. No Miranda or due process violation. That's okay. That's ridiculous. Now, how the police can mess this up? Well, if they generate a false document, they say, we have the actual DNA report. We have the fingerprint report. It's right here. If they start making documents that are fake, well, that's going to cross the line typically. And there's a case called State v. K-Word, but they can't cross line with these fake documents. Now, the modern version of this fake forensics is going to be cell phone pings or even more so DNA. Listen, that stuff takes time to get, but officers overplay their hand because used to seeing this on TV, the rapid fire DNA, rapid fire cell phone stuff. But that's not how that works. So it works on people because people have such a psychological susceptibility to this. Oh my gosh, my fingerprints, they got my DNA, they got my cell phone. I can't fight that. The best way to avoid this, number 1, don't go into an interrogation room without a lawyer. And then if you find yourself in an interrogation room without a lawyer and they start saying this stuff to you, simply say, I plead the 5th. I want a lawyer. Problem solved. Legal lie number 4, the bogus polygraph fail. You flunked the lie detector test. Why keep lying? You're just digging yourself in deep. People v. Henry, which is a New York case, basically came to the suspect who just did a lie detector test and say, hey, you failed, man. Sorry about it. Tell us what would happen now, or else it's going to get bad for you. Now, this was determined to be okay under the New York case because it's just being a little sneaky, right? That's fine. There's no fundamental unfairness telling a little fib to somebody. I think that's ridiculous. Now, again, this can easily turn into a not allowed confession if the police start creating fake documents. We have the results right here, and you can see this line indicates you can't create fake documents, basically. But keep that in mind. And the reason why the failed polygraph trick works is because people think these polygraphs are just the absolute best in the world. They're not. They're not the best. I don't know of any court that actually allows a polygraph into evidence. They're not allowed because they're not scientific. They're just not. They're subject to interpretation by another human being. They're not scientific. Now, a couple different things. You should never take a polygraph without talking to an attorney. And if your attorney tells you to take a polygraph, you really want to make sure that's the right attorney for you. Because even if you pass that polygraph, guess what? That past polygraph isn't going to be allowed into evidence unless there's some sort of deal with the prosecutor. So don't take polygraphs, number one. Number two, if somehow an officer is telling you failed the polygraph, don't fall for these type tricks. Even if you're guilty of sin, the response to that is, I plead the fifth, I want a lawyer. Problem solved. The fifth legal lie, and I don't like this one. This one makes me mad. But basically, they put a police officer in the jail cell with the suspect, and the suspect does not know the police officer is a police officer. They think he's just someone also been charged with a crime. And the person confesses to this fake police officer / a cellmate. And the Supreme Court in Illinois v. Perkins said, hey, not a big deal. If he doesn't know it's a cop, he can't be felt compelled by law enforcement. So that type of confession is A-OK. Now, there are limits to this jail cell police officer confession. Once formal charges are filed and the right to counsel attaches, you can't have an undercover officer questioning a suspect in a jail cell. It doesn't matter if the suspect knows they're an officer or not, because that would going to violate the Sixth Amendment of the United States Constitution. So, again, if you happen to be in jail, people in jail are not your friends. So if you find yourself in jail and people are asking about your case, stop talking to them. What you tell them is not confidential. And in fact, if you talk about your case, they're going to call their lawyer and say, hey, listen, I got some updates and got some news on this guy, and he confessed to me. See if the prosecutor will give me a better deal if I testify against him. That's a jailhouse snitch. That happens all the time. Don't talk about your case. Remember, cops can bluff evidence, but typically they can't threaten, promise, or trash your constitutional rights. That's when courts will step in, but they're allowed to bluff. Now, let me know which of these legal lies shocked you the most. Leave a comment. I will try to respond to all comments. Can't promise that, of course. But if you've watched this long, please like and subscribe this video. But most importantly, remember to always plead the fifth.